Leaving the United States to finish your green card process is a legal gamble that could trap you outside the country for 10 years. Under Section 245 of the Immigration and Nationality Act, adjustment of status is your legal shield, allowing you to transition from a temporary visa to a green card entirely within U.S. borders. But there are 10 critical landmines buried in this process that cause thousands of petitions to be denied every year. Stay with me. Your permanent residency depends on it.
Section 1. Who qualifies for adjustment of status? Immediate relatives of U.S. citizens, spouses, unmarried children under 21, and parents qualify without waiting for a visa number under INA 201B. Employment and family preference categories must wait for a current priority date. Under INA 245I, certain applicants who were grandfathered before April 30, 2001 can still adjust status despite entry violations, but only if a qualifying petition was filed before that date.
Section 2. The Priority Date System and Visa Bulletin. Each month, the State Department publishes the Visa Bulletin showing which priority dates are current for each preference category and country. Your priority date is set when your petition is properly filed. You must compare your priority date to the final action dates chart, not the dates for filing chart. When your date is current and a visa is available, you may file Form I-485. Section 3. Form I-485 Danger Zones. Part 8 of Form I-485 asks about criminal history, immigration violations, and membership in certain organizations. Answering these questions incorrectly, even innocuously, constitutes fraud under INA 212A6C. Do not answer based on your interpretation. If you were ever arrested, even if charges were dismissed, you must disclose it and attach certified court dispositions. Concealment is a permanent bar to immigration benefits. Section 4. The Required Documents Checklist. You must submit a certified copy of your birth certificate, valid passport, 2 passport photos, Form I-94 arrival record, all prior immigration approvals, police clearances from every country you lived in for more than 6 months, marriage certificate if applicable, and financial documents. Missing even one item results in a request for evidence that pauses your case and extends processing by 3 to 12 months. Section 5. Form I-693 Medical Exam Timing Trap. The medical exam must be performed by a USCIS designated civil surgeon and is valid for 2 years from the date of the civil surgeon's signature. However, if you submit the I-693 more than 60 days before filing I-485, USCIS will reject it as premature. If you submit it too late and it expires, you must get a new exam. Time the exam to be completed no more than 60 days before filing and ensure it arrives with your package sealed.
Section 6. Affidavit of Support and the 125% threshold. The I-864 Affidavit of Support requires the petitioner to demonstrate income at 125% of the federal poverty guidelines for the entire household size, including the intending immigrant. For 2026, that means approximately $26,000 for a household of 2. If income is insufficient, you need a joint sponsor who must file their own separate I-864 with their complete tax returns and proof of domicile in the United States.
Section 7. Advance Parole versus traveling on your visa. If your I-485 is pending, leaving the United States without an approved Form I-131 Advance Parole is deemed an abandonment of your application under 8 CFR 245.2. This is true even if you hold a valid H-1B or L-1 visa. The only exception is for H or L visa holders who re-enter in that same status. Never book international travel with a pending I-485 without first confirming your advance parole is approved and in hand.
Section 8. Employment Authorization Combo Card. When you file I-485 concurrently with I-765 and I-131, USCIS issues a combo card that serves both your employment authorization document and your advance parole. This means you can work for any employer in the U.S. and travel internationally while your green card is pending. Critically, once you receive this card, you should not continue working on H-1B if doing so would trigger abandonment of a portability strategy you need.
Section 9. The I-485 Interview. USCIS conducts interviews primarily for family-based cases. The officer will compare your verbal answers to everything on your I-485 and supporting documents. They look for hesitation, inconsistency, or evasion on questions about the bona fides of your relationship. Bring every original document you submitted. If asked about your marriage, both spouses must tell the same story with the same specific details. Inconsistencies trigger a Stokes interview, a separate, grueling examination conducted in different rooms.
Section 10. Common I-485 denials and how to respond. The top denial grounds are inadmissibility bars under INA 212, misrepresentation on the application, failure to maintain lawful status, public charge determination, and criminal grounds. If denied, you have 30 days to file a Form I-290B Notice of Appeal or Motion to Reopen. Do not refile a new I-485 without first addressing the denial ground. Consult an attorney immediately upon receiving a denial notice. The clock starts the day you receive it.
The adjustment of status process is survivable, but only with precision. One wrong move on the I-485, one trip without advance parole, one misread of the visa bulletin, and your green card disappears. Subscribe now for weekly legal intelligence that protects your immigration status. Drop your question in the comments, and I will answer it in the next episode. This is your legal advantage. Use it.